Good afternoon and welcome back to the Tuesday, August 1st Board of County Commissioners meeting. This is our 9 a.m. meeting and we were on item number 16.
Move to come out of executive session.
Second.
That has been moved and seconded. I'll call the roll. Commissioner Williams.
Aye.
Commissioner Vanderwerf. Commissioner Gonzalez.
Aye.
And I'm not sure if Commissioner Geithner is online yet. Okay, and the chair votes aye. We are out of executive session.
Madam Chair, if I could make a quick statement, the board's exited executive session where legal advice was given and direction was given, but no decisions were made.
And we are adjourned. Okay, thank you for your patience. We went ahead and came out of our morning meeting executive session in order to give the clerk and recorder time to change over the systems and ensure that the recording starts as it should. So we have a couple more minutes. Thanks. Good afternoon and welcome to the Board of County Commissioners Land Use meeting. I will call this meeting to order. First item of business will actually be to excuse Commissioner Geithner. If I could get a motion to do so.
I move to excuse Commissioner Geithner.
I'll
That
second.
has been moved and seconded. Commissioner Williams.
Aye.
Commissioner Vanderwerf.
Aye.
Commissioner Gonzalez.
Aye.
And the chair votes aye. Commissioner Geithner is excused for the duration of this land use meeting. Item number 1.
Item number 1 is staff emergency items, and I'm unaware of any.
Item 2.
Item number 2 is changes, postponements, and notice of the next meeting. I'm unaware of any changes or postponements today, and our next meeting will be Tuesday, August 8th at 9 a.m.
Thank you. And before I move on to item number 3, I understand that there may be some people here today to provide comment on 2 specific matters. One involving a special permit application for Colorado Pumpkin Patch, another one involving potential development near Monument. And I just want to let you all know that neither of those matters are being heard today and that there are not, no action has been taken for those to be heard before us at this time. We are always happy to hear your comments and just be aware that if those items, if either of those 2 are agendized at a later time, there will be a full public hearing, and any comments that you offer today, you're welcome to come back and state those when they're officially on our agenda as well. But in order for them to be considered part of the true public hearing, just be aware that anything said in public comment today is not a part of those items if they are agendized at a later time. Okay, with that, is there anyone here in the public wishing to speak on an item that is not on the agenda today? Please come down, sir. State your name and your 3 minutes may begin.
My name is Ted Bruning. I participated in land use hearings a few months ago, and you just said you're happy to hear our comments. I thought about some things I saw go on, and I thought I'd come and suggest some possible modifications and so forth. Thank you. I think I probably can make this proceed. So what I'm talking about would also apply to planning commission meetings. As far as I can tell, there's just one set of procedures for both. So also for hearings here. What I had in mind was what you, Madam Chair, were charged with, full and fair due process, as well as efficient and effective use of time. So we'll see. You all may remember what I'm talking about. So the first thing actually is due to my not making a living in this environment, was new to this. And there were some things I discovered as I attended the meetings. I was in communication with a very helpful member of your team, Rebecca Rudder, but she was unable to give me crisp answers to some questions like things regarding public comment limited to 3 minutes. I was unable to find that written anywhere. I call these practices as opposed to rules. I don't know where they come from. I think they're appropriate, but it's helpful if we are showing up as a member of the public, if we can understand those practices or rules before we arrive. And I was in touch with the office and no one could give me a crisp answer. So the first is that public comment is limited to 3 minutes. And then this practice, I think we called it donating time. You ask the audience who else is here, who would donate their 3 minutes for someone to speak longer than 3 minutes. That's an undocumented practice as far as I could tell. I think it makes perfect sense, but it would be helpful if that was documented so those of us who aren't here frequently were aware of it. And maybe you all know where it's documented. I couldn't find it on the website, whatever. The other kind of associated thing is you have wonderful audio-visual resources, the projector, the help of the staff here to do things like this PowerPoint. Again, I was not able to get a crisp answer. You know, what could I do? When could I show up? Who do I give it to? Do you need it 3 days in advance? Didn't know. So might this be documented, webpage, so forth? That's the first. The second comes to rebuttal. You're familiar with your process. The applicant makes a presentation. There are those who voice their approval, those who voice their objections, and then there's rebuttal. And in this particular,
Sir, do you think you could wrap up your comments? I will say that I think we do have some answers to these questions, and if you could wrap
I'll
up your
move quick.
comments in about 1 minute, that would be
you.
great. And then we'll make sure we're in touch with you and then I'll make some
that
comments
one's
about
easy.
transparency afterwards. Thanks.
The rebuttal, in the case of the hearing I participated in, Commissioner Gonzalez questioned twice whether the rebuttal was actually a rebuttal. Turns out that the presentation was 33 minutes. The rebuttal went on to 55. And how do you manage that? I think as chair, you were asked about that, and it was a very awkward situation to be in. I have a couple of proposals. The first one would be that you simply limit rebuttal to 3 minutes. That might sound heavy-handed. However, the applicants have had unlimited time to make their presentation. The opposition gets 3 minutes, and you as commissioners can ask questions if you need to know more than what is presented in rebuttal in 3 minutes. So it would level the playing field a great deal. An additional one would be ask that in rebuttal, they describe specifically what they're rebutting. We heard 50 minutes of a lot more than that. So then the final one is a question about spot zoning. That term doesn't show up in any of our county documents. It appears to me that it is Colorado state law. You know, you have attorneys here. I'm not an attorney. I saw someone state that they had spent more than $20,000 pursuing a change. And it would appear to me that had they been considering spot zoning, they might not have spent that money. So if it were possible for you to say something about the county or county commissioner's position with respect to spot zoning, I think that would be helpful. Thank you.
Thank you, sir, for your input. And generally, in public comment, we don't get into a back and forth. You've raised some great points, and I do want to make sure that we circle back with you. Most of this is fairly spelled out in our rules, policies, procedures, and specifically on the process of a land use hearing with an applicant, and then citizen comment and the opportunity for rebuttal. That is very, very spelled out how we are to run those hearings by state statute. So we do our best to follow those and essentially ensure and try to steward in a fair hearing regardless. But in the interest of transparency and receptiveness, I think we'll make sure we get back in touch with you. Did you sign in with some contact information? And you have some great ideas about providing more transparency for what is expected and how we do run our land use hearings and what laws and statutes and board rules are governing those. So thank you very much.
Your attention.
For the record, I do remember your email, and I did send it over to our director of our planning department. So thank you.
Thank you, Mr. Bruni. Is there anyone else here wishing to speak on an item that is not on today's agenda? Okay. Hearing none. Item number 4. Actually, anyone online? Sorry. Okay, thank you. Item number 4.
Item number 4 is the land use consent calendar, inclusive of items 4A through 4G.
Is there anyone here wishing to speak on any of the items on the consent calendar, items 4A through 4G? Hearing none in the audience. And anyone online? Okay, and as a reminder, we did excuse Commissioner Geithner at the beginning of this meeting. So do I hear a motion and or discussion from commissioners?
I move approval of the consent calendar, items 4A through 4G.
Second.
That has been moved and seconded. Commissioner Williams,
Aye.
Commissioner Vanderwerf,
Aye.
Commissioner Gonzalez.
Aye.
The chair votes aye with Commissioner Geithner excused. That passes 4-0. Item number 6.
I think we're on item number 5, but yeah, item number 5 is the called up consent calendar, and there are no items called up. Item number 6, vacation and replat, 1384 Buckwood Lane, vacation and replat. A request by Murphy's Custom Homes for approval to vacate and replat 1 residential lot into 4 residential lots. The 3.81 acre property is zoned RR 0.5 residential rural and is located at the northwest terminus of Buckwood Lane, approximately 1/10 of a mile from the intersection of Buckwood Lane and Fawnwood Road. This item was heard as a regular item on the agenda at Planning Commission. The vote was 7-0 for a recommendation of approval to the Board of County Commissioners. The discussion included previous projects that split and combined the land over time, and that this proposal meets the zoning requirements. Parcel number 711-110-1042, Commissioner District Number 1, VR 22-013, Ashland Matthew, Planner 1, Planning and Community Development.
Good afternoon. My name is Ashlyn. This is Project VR 2213. This is 1384 Buckwood Lane, vacation and replat. My name is Ashlyn Matthew. I was the planner on this project, and Ed Schoenheit was the engineer reviewer for the project. Public input. If you are watching remotely and have not provided a name and a reliable phone number, please email that information to pcdhearings@elpasocode.com. Criteria of approval. Section 7.2.3, approval criteria for vacate and replat. The replat complies with this code and the original conditions of approval associated with the recorded plat. No nonconforming lots are created, and in the case of existing nonconforming lots, the nonconformity is not increased. The replat is in keeping with the purpose and intent of the code. The replat conforms to the required findings for a minor and major subdivision, whichever is applicable. Legal and physical access is provided to all parcels by public right-of-way or recorded easement acceptable to the county in compliance with this code and the ECM. The approval will not adversely affect the public health, safety, and welfare, and where the lots or parcels are subject to any CC&Rs or other restrictions, that any potential conflict with the CC&Rs or other restrictions resulting from a replat have been resolved. Planning Commission. So at Planning Commission, a motion was made to recommend this project for approval unanimously. The item was heard as a regular item, and neighbors did attend to discuss their opposition. Some of the reasons we heard with opposition were the property had been understood as an open space by certain folks. We had concerns about wildlife and the CC&Rs, and so this property has gone through multiple processes of being combined and whatnot over time. So, but that has been deemed consistent with previous plans and projects. The request by Murphy Custom Homes for an approval to vacate and replat one residential lot into 4 residential lots. In doing this process, the applicant is proposing to replat the lot into 4 lots, which follows the original configurations that you'll see over time with this area. Here's a vicinity map. So right here where the stripes are, this is going to be the one parcel or one lot that is going to be potentially vacated into the 4. And then this is showing an exhibit here. So this is what the final plat looks like. So as you can see, we have a giant one parcel here, and then we're going to split it into 4. Over time, we've seen this happen multiple times with this lot, where we've seen multiple configurations of being combined and separated. Dimensional standards. So the zoning district out here is RR 0.5. The width at the front line setback is 100 feet. Your front setback is 25 feet. Side setback is 10 feet. Rear setback is 25 feet, with any accessory structures being at 5 feet. We have a maximum lot coverage of none, and then your maximum height is 30 feet. We have some additional notes with this zoning district. And you guys, if you just want to let me know when to go to the next slide. So the master plan place type, this is suburban residential. So this area is going to be characterized by residential areas, mostly single family homes. So with what we're talking about with this proposal with a vacate and replat, we'd be creating those 4 lots. And this is consistent with the place type, where it has the potential to have single family residences on them, and all these lots do meet the minimum zoning requirement. So this, I would say, it falls within, and it is supported by the master plan. Area of change, we have minimal change developed. So this area, you'll see a lack of development. We'll also see that there are natural areas to be found out here. I think that this is being matched with the master plan. There could be new development out here, and within this area of change, we see that new development is welcomed. For the key area, this is the Tri-Lakes area. So this is going to be used as an area that is good for commuters going to Denver. We'll also see out here that we can have, again, development out here. We can see residential, commercial. So by having this proposal, this is in line with the master plan as far as doing and offering something that can not only help the community, but it can benefit for any sort of commercial purposes as far as bringing more people into the area to benefit the community overall for expansion. I'm going to bring Ed up.
Good afternoon, Madam Chair, Commissioners. So on transportation, there's ample public access with the local county roads that are there in that vicinity. And so all lots will have ample access. Driveway access permits will be required for the lots, no change there. Traffic study not required just due to the low traffic generated from the additional lots. Road impact fees will apply that if not paid at the time of recording will be paid at the time of building permit, barring your questions on transportation. All right. And drainage and erosion outside the floodplain, so no drainage issues expected. The property through its history had been replatted in the past, and so it had paid drainage basin fees quite a few years ago. So no additional drainage basin fees will be required because it was previously platted as 4 lots before. But the bridge fees were not paid at that time due to the program, and so those fees will be paid when the plat is recorded. Drainage report was submitted, was reviewed. No negligible drainage impacts are expected, and no public improvements are required. Barring your questions.
For hearing notifications, 18 notification letters were sent out to adjacent neighbors June 14th. Multiple emails were received from neighbors voicing their concerns about the proposal and today's hearing. So we have from left to right, picture 1, 2, and 3, and these are just showing the multiple signs that were posted around the property to inform neighbors of what is going on. Applicant is going to be Murphy's Custom Homes, and then representative is Murphy's Custom Homes as well. Public input, if you are watching remotely and have not provided a name or reliable phone number, please email that information to pcdhearings@elpasoco.com.
Commissioner Gonzalez.
Thank you, Madam Chair. So the first slide where you had the setbacks and everything, I don't think we actually showed I hope is probably the most important part of decision making here. 0.5 zoning, what's the minimum lot size?
It's going to be half an acre.
And then are all 4 larger than?
I'm going to pull this slide back up. I'm so sorry. Let me just go back here. Okay, so on the plat, if there's any way to zoom in. So each of these parcels does meet the half an acre, but we have most of the lots being over half an acre. Sorry for not clarifying that earlier.
And can I ask, I missed the question, if water rights have been acquired, or these wells, or, and I can leave that for Mr. Murphy.
We do
Or
have,
Mr. Martin.
we have, sorry.
Whoever's coming up.
We have letters up.
Okay, thank you.
I'm going to pull yours up.
Are there any further questions of staff? Okay.
And then you can just click this one. Yeah.
Hello. First of all, thank you for your time today. My name is Tim Murphy with Murphy's Custom Homes, and this is an introduction to the Westview Woodmore filing. And as you'll see, this property has changed shape a few times, and this is a table of contents, just sort of the information we have today. I'll go through that. The first thing I did when I heard about the property is I went to the Woodmore Homeowners Association and talked to them about what I wanted to do. And they said it was within norm. The next thing I did, I went to the assessors to check how it was zoned, and it was zoned R-0.5, which is half acre, and all of the lots exceed that. And in fact, in looking through the records, the property has been 4 lots for over 47 years of its history. So it's been 4 lots for a long, long time. And this is some of the history of it. In 63, it was originally subdivided. So those lots were all there, utilities were all available for the lots, et cetera. And as you asked, all 4 of the lots exceed the half-acre requirement. This is Buckwood Lane, so you can see that it's still the 4 lots. And this is still, here's Buckwood, there's a house here, and it's these lots adjoining. So this is the one parcel that's going to be broken into 4, like this. We believe that we've met all the criteria for approval. We've gone through this quite lengthily. And this is from the Woodmore Improvement Association, the approval letter. And this is things that were in the approval letter were, there were some stipulations to take down some fences and to mitigate some things around Buckwood Lane. And those have all been completed and done. And there's utility commitments for the four lots. Part of the agreement with the Woodmore Association was to pay all of the past dues for the 3 lots individually, because dues hadn't been paid for the 3 individual lots during a 10 or 13-year period. So we had to pay all of those back on an individual lot basis. So they looked at them as 4 lots. Then they also said we have to recommence paying those dues on a 4-lot basis individually. So. And I did read some of the comments from neighbors and stuff, and one of the things was fire. And I've met with the forestry department twice regarding the property, and we've gone through it, and they made recommendations, marked trees and so forth, and we've cleaned that up twice now with them. So, and with each property that we do, we will be doing a fire mitigation process with that as well. So it's actually going to reduce the risk of fires opposed to it just being left alone. So thank you. Do you have any questions for me?
First of all, can you tell me where is the entrance for Lot 2A? Is it coming in off of Buckwood? 2A is the one on the bottom. Yes, thank you.
This one is coming off of Doewood.
Okay. And then can you go back to the criteria that I was able to read the left side, the double table about 2 slides behind?
Back this thing up. We'll see.
That one right there. Thank you.
Yes, okay.
Okay, thank you.
Yeah, and Ashton had gone over that earlier as well.
Commissioner Gonzalez.
Thank you, Madam Chair. So how long have you owned the property?
Pardon me?
How long have you owned the property? You said it had not been paid some back dues or fees?
We bought the property last year,
Okay. It hadn't been paid up for how many years?
I believe 10 or 13.
Okay. I don't know how the metro districts work. A lot of areas, and who you had to pay for that, but normally they would put a lien on the property, and when they sold it to you, the other property should have paid those fees. And I don't think you're being treated fairly by that district, making you pay for the back 10 years. So I just want to put that on the record.
Okay,
I believe there should be a method where the previous owner should have been held to what they had to pay, and the district should not have made you pay for that. Thanks.
okay. And the deal is it's X amount of dollars per lot, and the previous owner can change it from 4 lots to 1 lot, and he only had to pay the dues for 1 lot. So we just had to, part of the agreement was we'd pay the rest. I'd be glad to happy to talk to him about that, though. But it's all been paid up.
Are there any other questions for the applicant at this point? Okay,
Thank you very much.
thank you. So we will begin the public input portion of this public hearing, and we will start with anyone in support of this application. Just show of hands, can I just let me know if you're here in support of the application? Okay, if you can come forward, sign in, state your name, and your 3 minutes can begin.
Hi, I'm Sarah Martin. I'm also with Murphy's Custom Homes. The only thing I wanted to address, and it was earlier on the slideshow, is in 2010, it was pretty much in the exact same configuration as to what we're putting it back to. So he kind of just, he made it into one, which was nice because he paid taxes on one property and didn't have to pay vacant tax. Yeah, so there's a lot of advantages to having one instead of paying vacant tax. But just so you guys know, from 2010, that's kind of what we're going back to.
Thank you. Can I get the clock restarted when you're ready, please?
Hi there, I'm Shane Martin. I'm also with Murphy's. And, you know, we bought this to make it into 4 lots again and build houses on it that people are going to love. And it's going to help improve the community because, you know, if you don't know Murphy's, we build awesome houses. And like Tim said, that we are also going to do fire mitigation and just help out the community. Thanks.
Thank you. Is there anyone else wishing to speak in support of this application? If so, come on forward, sign in, state your name. Okay, is there anyone online in support? Okay. With that, we will move now to anyone here wishing to speak against this application. Just come forward and sign in and state your name, and your 3 minutes can begin.
Hi, good afternoon. I already signed in earlier. My name is Sarah Cole. I am a resident at 19411 Wildwood Way. You don't have the plat map up anymore. We would be lot 6A, so adjacent to this property. Oh, thank you. 6A there off of the cul-de-sac on Wildwood Way. They've given some great history. I know on paper it looks like all the boxes are checked. Yeah, all the lots are within the 0.5 acres. My hope today is that you hear the side of the story from longtime homeowners that have lived in this area. I purchased, my husband and I purchased this lot 6A in 2010. Other surrounding neighbors have been in the area as long as 30, 35 years, longtime homeowners in Woodmore. Before we purchased in 2010, the owners at 19411 Wildwood Way sold a small sliver of land off the back portion of that property to Mr. Gross, who owned 1384 Buckwood. At that same time, that is when he also requested that the 4 lots be turned into 1. Perhaps it was to avoid some extra taxes, some extra HOA fees, perhaps, but he also had additional justifications. He sent a letter out to adjacent property owners in 2010, and he cited a number of items from the 2000 Tri-Lakes Comprehensive Plan. That's the most recent comprehensive plan for Tri-Lakes area, and it has been approved by El Paso County. Just some of the justifications he's mentioned, and this is for combining all 4 lots, is erosion issues, areas of steep sloping, lots that are marginally buildable due to the slope of the lot. The overall roadway system in Woodmore is not adequate for additional population, and county services such as police protection that are not adequate to meet the needs of residents of Woodmore. The justifications for combining these 4 lots in 2010 are still relevant issues in Woodmore today. Mr. Murphy's own soil survey reported 40% sloping on portions of these lots. They spoke to drainage, but they didn't speak to erosion. Lot 4A has 40% sloping down, where lots 58, 57, and 56 have experienced flooding already without additional homes on that hill. The lots continue to remain marginally buildable. I'll be really quick. Demographics in this area have changed drastically since 2010, causing roadway usage and congestion to increase, yet our roadway systems remain completely unchanged. Police protection remains inadequate for the rising population and change of demographics, and the combination of these 4 lots act to preserve the unique identity of the Woodmore area overall. This is not an area designed for high-density housing, and quite frankly, the Tri-Lakes area does not need 3 more $1 million homes. The request to combine the 4 lots into one was approved by El Paso County in 2010 based upon justifications that are still valid today. As homeowners, we have invested money in our own properties based upon the fact that El Paso County approved the combination of lots and the expectation that this area would remain undeveloped. We feel it's your responsibility to uphold the decision your predecessors have already made in regards to this property. I appreciate your time.
Thank you. If you would please sign in, state your name, and your 3 minutes can begin.
Good afternoon, Commissioners. I'm Joanne Schmitz. I'm the property in the back of 4A on the 40% grade there, and we are experiencing flooding right now. I've lived there 35 years, and we currently have 2 sump pumps to keep our basement dry because of the drainage in this valley. We're here to review a proposed change to the plat. I believe the Colorado Common Interest Ownership Act, which I don't know the official name is at Kiowa, applies to the Woodmore Homeowners Association. Okay, this isn't a test, but Colorado Revised Statutes 38, 33.3, 117, Section 1.5D is applicable to the common interest communities that are formed before July 1st, 1992. And WIA was formed in 1971. And for actions after July 1st of 1996. I would argue to you that the Kiowa applies via the HOA and the CC&Rs to your decision. CRS 117, which I just cited, refers to 38, 33.3, 2171 as applicable. It is entitled Amendment to Declaration. And what we have here is the declaration. This is an pertinent part of that statute. The declaration, including the plats and the maps, may be amended only by the affirmative vote or the agreement of unit owners of units to which more than 50% of the votes in the association are allocated, or any larger percentage not to exceed 67%. So what's happened here is the HOA board has made this decision and it has not put a vote out to the membership for approval of this amendment or change to the plat as required by Colorado statutes. There's no vote for a declaration amendment allowing for this to take place as required by Section 217. So I would therefore argue to you that this proposal is premature and the HOA has not met its requirements. It's not consistent with the CCNRs, and you should be tabling this decision or denying it until that can be further investigated. Thank you. Whoa, 15 seconds. It's amazing that never happens.
Is there, are there any questions for this testimony?
I was going to give
thank you.
Mr. Hodge a quiz here, but he's looking him up now, so.
Thank you.
Thank you.
Is there anyone else here in the audience wishing to speak in opposition to this application? Okay. If the applicant would like to come forward and address any of the issues brought up during the testimony, you're welcome to do so now.
Yes. I do know that the WIA had their attorney review their questions and things that they were after, and they looked at it and denied doing anything about it. So the other thing is the soils and erosion things. We address every new build site on a per site basis, and we handle erosion, and we've had soils engineers test it, and so the erosion and stuff is much better when we get done with a property than when before we start, because we can control where it goes and what's happening and retain what needs to be retained. So it actually improves the situation when houses are built correctly.
Just some questions.
Commissioner
So
Williams.
And
I
as
know
far
that
as
we-
being unbuildable lots, they just need to ride with me for a few days. I control them some unbuildable lots that I get asked to build on, so these lots are just fine.
Okay, so my
Commissioner Williams.
question, I will ask staff too. I don't know if we have notations and conditions on this, but we have had a lot of rain this year. And so we know that we're getting in a large amount of drainage in the conditions. Is there anything addressing the drainage and the flooding that might occur when you build on these lots? I don't know as if, that means a retaining wall or something.
Well, we had an overall drainage report done of the whole property.
Mm-hmm.
And then when we build, we individually address each particular lot in that regard. We
Okay,
do a drainage report and get a drainage engineer involved.
all right, thank you.
Okay.
Commissioner Vanderwerf.
Yes, thank you. And my question may be for you, Mr. Murphy, also for the staff, but since I've heard it alluded, well, it's been alluded to, is there an HOA that has any governing authority on these properties?
Yes,
Yes.
Woodmore,
I'm sorry?
Woodmore Homeowners Association.
Woodmore HOA?
Yeah, they
So I-
run the letter.
I think the answer is the Woodmore Improvement Association.
Yes,
But-
Woodmore Improvement Association.
That would be homeowners association law. That's not something that we consider in this hearing.
Excuse me, sorry. I was just gonna say, he does have, there is an HOA for the area. They reviewed this and looked at what his proposal was, and they sent him back this letter. Also, as a reminder, the El Paso County, we're, our own jurisdiction, so HOAs aren't gonna have, aren't gonna be a governing body that would have any significant role over how we move forward with approval of a project, if that makes sense. So if we're approving something, the HOA might have something different to say about it, but it's on the applicant to tie up those loose ends as far as approvals for different proposals.
Okay, so in looking at the letter, it says that according to the Woodmore Improvement Association, you rectified all of the covenant violation stipulations pursuant to the approval conditions set forth. So this was approved by Woodmore Improvement Association, assuming these covenant violation stipulations have been or will be fixed, but this approval was on June 15, 2022. That's the date that's in the letter.
Yes.
Actually, the letter itself is 2023. So,
Right.
I
They
think,
had approved it prior, and then once I got all of the loose ends tied up, I had them come out and inspect it again. Letter.
okay.
They'd approved it some time back.
but
Williams.
I would hesitate. So this is an improvement letter, I think specifically to the late fines and fees, maybe some other things, but I would hesitate to, I'm not an HOA law expert, so I would hesitate to disagree with the constituent here who also thinks that she may still be able to take it to the HOA. That's something the HOA would have to clarify after we make
They
a decision
They
here.
did get an attorney to go
Okay.
talk to the HOA, so.
Mr. Hodges.
This is just a
Thank
letter
you, Madam.
stating that everything got done.
Sorry, sir, I didn't mean to cut
Go
you
ahead.
off. Thank you, Madam Chair. Just a quick clarification. Kiowa and HOA law are not relevant to the county's land use process. That's actually a contractual legal matter between property owners and their association.
Thank you.
Are there any other questions for the applicant? I have one, and that is whether these three additional, it was 4 originally platted homes. What, does the infrastructure exist? I mean, are there taps running to these properties individually already?
They are available. They don't run them till you're ready for them, but they are available. And they've
Okay.
got the main lines ran, yes.
Okay. Thank you. All right, with that, we will declare the public hearing portion of this land use hearing closed. Mr. Hodges, actually, I think, you know what, we'll take a brief recess, but the public hearing portion of this is closed. We will come back for discussions and a motion. Good afternoon, and I will call this August 1st land use meeting back to order. I believe that our county attorney wanted to make a statement.
Thank you, Madam Chair. Just a real quick clarification. And I don't say this to be rude to any member of the public, but my position involves providing legal advice to only the commissioners. I can't provide legal advice to the general public, so I would probably decline to answer follow-up legal questions.
Thank you very much. And this is a quasi-judicial matter, which you heard referenced earlier in the meeting. We have very strict rules around how those have to be run. And so with that, the public hearing portion of this item is closed. So do we have any further questions or of staff or discussion at this point? Commissioner Williams.
I did ask for the criteria of approval to be put up, and I did want to specify that just a few years ago, we approved a master plan, a comprehensive plan for the entire county that overruled the Tri-Lakes area plan. And I'm reading through these, we always ask for these to be placed up on the screen. In reading through these, I am seeing that the person who has brought forth this action meets all of these conditions. And that would be my intent to move this item forward for approval with any notations and conditions placed in the attached resolution.
Is that a motion?
Yes, I will do that.
Is there any other discussion or a second? Commissioner Gonzalez. Discussion.
Thank you, Madam Chair. So looking back, and so I asked the one question because it wasn't originally stated, was really, this is within the zoning request. I'll be honest, the First Lady's comments were very, very good. If you were asking, if the request was to rezone, this is a replat, instead of a rezone from say acre to half acre or half acre to quarter acre, because the lots were too small for the original zoning, I think your presentation was extremely strong. I would just say a couple of photos to showing the slope and issues would have been a little bit better. The only thing that could have made it better, I would be voting no. But this is not a rezoning. It's in the zone. It meets the criteria in my mind for that. So I'm going to be supportive of it. And the other concern that was brought up, good concern on any of the wastewater runoff, the flooding issues, any of those conditions would have to be met and approved by the engineers, saying that it does meet their criteria. So that's a valid concern, but those concerns would have been rejected by the planning department as they go through forward in the engineering criteria. They'd say you don't meet this, so you couldn't build the house, but that wouldn't stop the rezoning, saying you can look into it and try to do all the engineering required to do so. So again, I actually applaud you. That was a very strong presentation, but I think it meets the criteria of replatting. Thank you.
Commissioner Vanderwerf.
Yes, thank you. I'll go ahead and second the motion. And I do believe it meets the criteria as well. And I did have a similar question that Commissioner Williams had, was how would that southern lot have access to roads? But it actually was stated in some of the documentation. So it does have access. Thank you.
Okay. Any further discussion? Commissioner Williams.
Aye.
Commissioner Vanderwerf.
Aye.
Commissioner Gonzalez.
Aye.
And the chair votes aye, with Commissioner Geithner excused. Thank you. Item number 7.
Item number 7, Annexation Impact Report, Villages at Waterview North Addition Number 1. Acknowledgement of an Annexation Impact Report for the Villages at Waterview North Addition Number 1 annexation. Pursuant to state statute, the Board of County Commissioners does not approve or deny an Annexation Impact Report. The report provided by the City of Colorado Springs notifies the county of the annexation request and describes potential impacts in very general terms. The 144.82 acres is zoned RS 5000 residential suburban, RM 12 residential multi-dwelling, RM 30 residential multi-dwelling, CS commercial service, and I2 limited industrial, and located northeast of the intersection of South Powers Boulevard and Bradley Road. This item is scheduled to be heard before the City of Colorado Springs City Council September 12, 2023. Parcel numbers 55000000441, 452, 453, 454, 455, 456, and 457. Commissioner District Number 4, ANX 22014, Kylie Bagley, Planner 3, Planning and Community Development.
Good afternoon, Commissioners. My name is Kylie Bagley, and I was the planner assigned to this annexation. So it is file number ANX 2214, and it is titled Villages at Waterview North Annexation. Oops. And then Jeff Rice, who is a senior engineer, was also assigned to the review of this annexation as well. If you have any questions for him, he's here and would be happy to answer them today. So the county did receive an annexation impact report for 144.82 acres, which is located northeast of the intersection of Powers Boulevard and Bradley Road. The subject property is intended to be annexed into the city of Colorado Springs. It does include a multitude of zoning districts, which include I2, industrial, CS, commercial services, RM 30 and RM 12, which is residential multi-dwelling, and RS 5000, residential suburban. This is just the annexation plat that was included with that annexation impact report. And it does show the bounds of what the city is going to see as far as the proposal for the annexation. A master plan was also included within the annexation impact report. So if the subject property does get annexed into the city of Colorado Springs, they are proposing a mix of different zoning districts, which includes public facility, mixed use large scale, light industrial, residential flex medium, and residential multifamily high. The project is scheduled to be heard for consideration by the city of Colorado Springs' City Council on September 12th. I would now like to invite our county attorney, Lori Seago, down.
Good afternoon, Commissioners. Lori Seago, Senior Assistant County Attorney. I've been asked to briefly cite for you the legal authority under which you are hearing this report today. The statute and the Land Development Code section are on the screen in front of you, and they basically provide that the city is required to provide you with this annexation report, but that is as far as they are required to go. Your options today are to take no action, or you can provide direction to staff, or even ask one of your own members to appear at the annexation hearing and provide whatever comments to this proposed annexation you deem fit. But there is no approval or disapproval authority that you have. Any questions?
Commissioner Vanderwerf.
Yes, thank you. Ms. Seago, you may bring this up, or maybe you're done with your presentation. I don't know if you've got some more, but for annexation statutory requirements, should they be annexing land that's adjacent to already annexed or current city jurisdiction? So in other words, it should not be its own orphan out in some location, right? And if that's true, is it the airport that provides that for this annexation, the property that's north of this, that provides that?
Commissioner, I don't review these applications to see if they meet the annexation requirements for the city. There is statutory requirement that a certain percentage, I believe, of the boundary be adjacent to other boundaries of the city. I don't recall off the top of my head what that percentage is or what that fraction is. I can certainly look that up for you if you're interested. But it can be, it could be the airport. It can be right of way. So you will occasionally see flagpole annexations where the annexing authority will annex right-of-way to get to that unincorporated property. But in this particular circumstance, I can't address how that requirement may be met.
Thank you.
So it is 1/6 of the property has to touch the town that they're proposing to annex into, and the airport would count. And so as you can see on this map, the grayish color is the city of Colorado Springs.
Okay. Now there's also gray in the southeast of that visual. Is that also city?
Correct.
I see. Okay. All right. Thank you.
So there will still be an enclave to the right there that would be completely surrounded by city limits. Okay. Does that conclude the staff presentation on this item?
Yes, it does. Thank you.
Okay. Discussion, and as was mentioned by Ms. Sego, we have the opportunity to provide any input in the form of direction to staff to provide that input, but there's no formal vote on our acceptance or denial of this report. It has been officially presented to us as a report. Commissioner Gonzalez.
Thank you, Madam Chair. So, I mean, we don't have to make any comments unless staff has any recommendations on roads issues that they're not taking roads they should be taking, et cetera, then it looks like a traditional, normal annexation request. So as long as staff doesn't have any recommendations to include a comment about recommended roads that should be taken with this, then I'm good with it.
Staff had no comments when reviewing this application.
I'm curious as to whether they intend to keep similar zoning, because these are our zoning categories, not the city's potential ones.
So from what I can tell from what they provided, it is fairly similar. They are proposing some industrial over in this area, some high-use residential, mixed use, which I would assume may mean commercial and multifamily, and then it looks like public facility, which I'm not sure what that zoning district means within the city.
And follow-on question? Oh.
Commissioners, Megan Harrington, Planning Director. Just one small item that I think is of interest. The accident potential zone for the airport does transverse this property from north to south, and that is on the western side of the property, and that's why you're seeing public facilities and industrial in that strip, the residential removed from the APZ2.
Thank you.
Thank you.
Commissioner Vanderwerf.
Yes, thank you, Madam Chair. It's kind of a follow-on to Commissioner Gonzalez's question. What happens to Powers Boulevard and Bradley Road in this area? Whose jurisdiction is it now, and who does it change as a result?
Afternoon, Commissioners. Jeff Bryce with Engineering. Powers is currently a CDOT right-of-way, and the City of Colorado Springs is in the process of annexing the rest of Bradley Road, but typically CDOT would control the intersection of Bradley and Powers as they currently do, yes.
So this annexation, thank you. So that intersection there, Bradley and Powers, is CDOT jurisdiction?
Correct.
And then Powers is not city jurisdiction at present?
No, that's...
Oh, Bradley
state,
is also
yeah.
state? Oh. No, Powers, yes, but I was asking about Bradley.
No, so Bradley is currently a county road for that segment shown on the map, but it's in process of being annexed or taking over for maintenance and ownership.
Okay, so it's the intention of the city to annex that?
Yes.
And do we have a sense of when that is, or we just have to wait for them to decide when they're going to do it, or?
I'm not sure about the timetable, but we can check on that and get back to you if you need that.
Yeah, it might be good to ask the city that question, what's their intention on timing for annexation of the Bradley Road? And I would presume they're probably going to continue to annex maybe south of Bradley eventually and also further east.
Not sure about that. To the south, directly to the south of this property, there's county residential development going on and a possible commercial site. It's possible they could annex that in the future, but currently that's developing in the county.
Yeah. I think per our annexation agreement, they're supposed to declare to us their intention about what areas they intend on annexing within a time window of a year or 5 years or something like that. I guess maybe my question could be a little bit more broad as to what are the other areas around here that the city has an intention of annexing. And it's not so much that I have an issue one way or another. It's just that I kind of want to understand kind of what's being planned for here.
Commissioner Vanderwerf, they are going through, the City of Colorado Springs just put out an RFP for their Annex COS annexation plan. So I can tell you right now what they have is a map of areas that they anticipate could be potential annexation areas, but that is not an officially adopted map yet. They are working to refine that. We will be part of that process. Again, the RFP is out, and then they will have a better plan for what areas they are determining for annexation. When we most recently met with the city planning staff, they're entertaining these annexations on a case-by-case basis as they are approached. They send us this annexation review early on in their process. That way we can comment on roadways that need to be annexed, any type of issues that the county would see. And we also look at that annexation agreement and discuss if those infrastructure improvements need to be constructed to city standards or if the county has an additional ask based on that annexation. So I guess that's my long, windy way of saying case-by-case basis at this point as they refine their plan for how to address annexation and growth in the future.
Okay. Yeah, thank you. That's very, very helpful. But I guess for the moment, Bradley Road will be maintained by the county, even though, well, I guess some of the users will be city. Some will probably also be county, so it'll probably be a mix. But Bradley Road will be maintained by county for the moment.
In the interim, it will be, yes.
Okay.
Any other comments or specific direction regarding input for staff?
We're just looking back at this map again. It looks like they might actually be including the road with this annexation too.
Oh, the road is included in the annexation?
Yeah, it's kind of blurry, but it looks like the boundary goes around the road right of way, yes.
This annexation plat takes in the right-of-way for that stretch of Powers adjacent to the property. So this is the annexation plat boundary to this point.
So they're picking up
They're picking up that section of
that
Bradley Road
section of Bradley.
and the section of Powers.
Okay, that makes sense to me, since they're going to annex that, and the quote-unquote city residents would be using that section of Bradley pretty extensively. I mean, there'll be county people using it too, but
Yes, and that annexation plat and the approval and the recordation of that annexation plat is the documentation they need that would transfer, maintenance ownership of the roadway over from county to city. That is all done as part of that annexation plat document.
okay, so I'll be working, at least I'll have the assumption that if city council approves this, it'll be the intention of the city to plow that section of Bradley Road for snow in the winter and so forth.
Yeah.
Correct, yes.
Yeah.
Okay,
That would be our assumption as well, sir.
let's hope that's a good assumption. Thank you. Okay, I'm good.
Okay, did we answer that definitively, or do we need clarification of intent to assume Bradley Road?
Chair, I think that's pretty definitive. It's included in the annexation plat as we look a little bit more formally at these boundaries. If it's in the plat, then they are anticipating taking that over. They've had no other conversations with the county that we would maintain any type of maintenance. We will make sure that we continue conversations with the city planning office, but I think that you can bank on that fact.
Excellent. Thank you. Okay, are there any members of the public wishing to speak on this item? And none online? Okay. There are no action items. Directions received. Item number 8.
Item number 8 is department and committee reports and non-action items, and there are none.
Item 9.
Item number 9 is the addendum, and there is no addendum.
Item 10.
Item number 10 is the executive session, and there is no request for an executive session.
We are adjourned.